Hello, my name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group. And we have offices located in Ridgewood, New Jersey, and northern New Jersey. We also have an office located in central New Jersey, in Neshtanek Station, which is close to Somerville and New Brunswick, and also close to Branchburg. We also have an office located in Midtown Manhattan, and we'd be pleased to meet with you or any of the members of your staff or your family in those offices. Today I want to initiate probably a 3 or 4 part series to discuss the recent changes that have happened in the H-1B arena. Specifically, and obviously it's been part of the news, is the tremendous number of RFEs, requests for evidence, that have been issued with regard to the H-1Bs. And obviously our office, like many other offices that are handling U.S. immigration law across the country who do H-1Bs, have been sent into a bit of a tailspin by the RFEs, number one, by virtue of the sheer number of RFEs that have been issued, but number two, by virtue of what we call the Level I Wage RFE, which is something that is relatively new, and so we have been working closely with other members of our colleagues and also within our office to try to design a precise response to the RFE questions RFE queries that are put forth by the U.S. Department of Homeland Security. So the RFEs generally, as many of you know, have a specific question with regard to specialty occupation. And obviously, in terms of the evidence that you can marshal to show that a particular occupation is a specialty occupation, one deemed a specialty occupation, is that the equivalence of a U.S. baccalaureate degree is required for that position. So how would you evidence that? Well, there are a couple of things that we can do. Number one, of course, is to show, of course, that the individual has the baccalaureate degree, but to take that one step further or deeper is to show that other individuals who are hired in that position in the organization also require a baccalaureate degree. So that can be shown by way of putting together an appropriate corporate chart or putting together recruitment materials that show specifically that individuals who are hired for that particular position have the requirement of the bachelor's degree. So in addition to that, you could also get letters from, let's say, other organizations. We call them industrial letters, and we can get letters from other organizations that are in the same industry, maybe the same size as the potential client, or we could get letters from other individuals who are knowledgeable about the industry, who can state that the equivalence of a U.S. baccalaureate degree is the minimum requirement for the particular position. So these are some of the ways in which we can deal with the specialty occupation question. The more challenging of the questions is the new question about Level I wage, because oftentimes employers designate Level I wages, and they do so because most of the time individuals who are coming to work for a particular employer, especially if it's a new individual, a new H-1B, they don't have training in the particular field, and so there's a ramp-up time. So essentially for a particular employer where an employee has to learn a skill set, there's a very significant ramp-up time, and that's why maybe a Level I would be permissible. Also, it's very important, of course, to actually go through the wage sheet, which the U.S. Department of Labor has online. There's a specific wage sheet where there are various steps. It's actually step 1 through step 5. And it was this wage determination methodology finds its genesis back in GAL 298, which was a memorandum that was put out by the U.S. Department of Labor that explains how to strike the federally mandated prevailing wage. So it's tremendously helpful to actually go through the steps and to show the U.S. government what the steps were on the wage sheet as to how the employer actually did the calculation of the wage. And of course, what would also be tremendously helpful, in addition to actually doing the wage sheet, is to provide maybe some sort of a step-by-step explanation or affidavit or even a flow chart by the employer that specifically lays out how that wage was struck and what the reasoning was behind why the employer decided that level I wage was the appropriate one. Of course, there's also a common sense component to this whole wage issue, and that is if you have an individual who's filing for an extension and then of course has ramped up and they're doing an H-1B extension, then obviously a level I wage wouldn't be the appropriate way to handle it, unless of course, let's say for example, the individual is still under the very, very strict scrutiny or auspices of their supervisor and being managed, I would even go so far as to say micromanaged by their supervisor. And so there are obviously different ways in which you can produce evidence to show how the individual is supervised or managed while they're in that particular position. So with that, again, I think what we're doing is we're seeking to initiate maybe a several-part series on discussing the various ways in which to deal with the Specialty Occupation RFE and also the Level I RFE. So that's about all for today, but we will be back to you with some additional thoughts on these issues. So if we can be of any assistance to you, to your HR, to a member of your staff, please feel free to reach out for us. Our email address is on the screen below. You can also feel free to check us out on the web at www.visaserv.com, or you can call us at 201-670-0006, extension 107. We look forward to being of assistance to you. Thanks for being with me today. Bye for now.